Hi, this is Jim Cunningham, and we're going to talk about what to do when someone important in your life passes away, the crucial actions. This is a pretty heavy topic. And just to be understand, I'm going to do a lot of talking. I'm going to go through a lot of things rapid fire. I'm going to be kind of touching the surface on a lot of these topics. This is not legal advice. Don't watch this and go out and do a bunch of stuff. If you're watching this on YouTube, please subscribe to our YouTube channel. You can click the subscribe button, also the little bell. It will alert you when we post new content. And you can go ahead and share it if you'd like, if you think this would be valuable for somebody else. We have offices throughout California, Northern and Southern California. This is our current team of attorneys. We are 8 lawyers devoted entirely to trust and estate and tax planning matters. I'm your speaker, Jim Cunningham. I've got over 25 years experience. I am the CEO and partner at Cunningham Legal, and I am securities and insurance licensed, also a single engine land pilot, and a certified specialist in estate planning, trust, and probate law, and have handled cases. As we go through this, I've handled a case in every single situation here. So really the question is what happens, not so much happens, when someone passes away spiritually. This is really what happens with all the people who are left behind. Because when somebody leaves this earth, people are left behind. You've got stuff, you have responsibilities, you have bills, you've got money that you might be entitled to. So we're going to cover just some really best practices when it comes to people passing away. And we're going to talk about business partners, spouse, child, tenant, boss, or a friend passing away. What can you do legally? What should you do? What shouldn't you do? What shouldn't you do is sometimes more important than what you should do. And we'll go beyond the grief and cover the next stages, the sort of the legal steps that need to be taken, and avoid some common mistakes. So I wanted this title to be All My Friends Are Dead. I don't know if you've read the book, All My Friends Are Dead. It's a very cute topic, but I've been working in this field for more than half of my life. So pretty much all of my adult life. And I can tell you, I've known a lot of people who've passed away, and many people, I think about them. I still think about them today. I was like, wow, that was a really cool person. And that person passed away. And it was a real honor and a blessing to be able to help them before they passed away. And certainly helping people after somebody passes away. It's a time of grief for many people. And I think for some people, there's also a feeling of guilt in the sense that if you're taking care of somebody and it's kind of sucking the life out of you, even though you love this person and they pass away, you might feel relieved. And then you feel guilty that you feel relieved and you're grieving. So there are a lot of different contexts here. And what we're going to kind of talk about is the do's and don'ts, if you will, of these particular 6 situations here. And I have, of course, I try to bring a little bit of levity to this. Mel Blanc's Tombstone, who, of course, was the voice of Porky the Pig and Bugs Bunny and all those great characters there at Warner Brothers. So a little homage to him. So death of a business partner. Let's start with a business partner. If you have a business partnership, which really means 2 people doing something. If you and I open up a lemonade stand and we go out there and we sell lemonade, $1 a glass, and there's no written agreement, we are business partners, right? Because we are not organized as a corporation or an LLC or anything like that. We're just a general partnership. General partnerships do not have to be registered, at least in California, with the state of California. Should you get an employer identification number? Well, yeah, but do you have to? No. I mean, if you're in that case of us selling lemonade on the street corner, that is a partnership. And it can be formal or informal, right? It can be a handshake. It can be a document that's 100 pages long. I would say that generally doctors, lawyers, professionals, accountants, consultants, finance tend to be organized as partnerships, and people who have non-professional practices oftentimes are organized as corporations. So you'll see that quite often. Now, that doesn't mean if you're not a physician, you shouldn't have a corporation for a variety of reasons. But I would say on a very high level, you'll see partnerships with the professions and corporations with operating businesses that are making things or selling services other than professional services. So what happens to the business, right? I think about what happens if you have a business partner and someone's passed away. It can be devastating, right? It might be the person who really is the engine behind the company. If your partner passes away, are you going to be partners with the spouse of your deceased partner? Are you going to have to buy that person out? Would they want to buy you out? Would you want to sell? There are a lot of different paths you can go down, but these things, if this is a sudden death, if it's something that's not expected, can really take people off guard. We talk about the context of death here. It's also if somebody becomes incapacitated, because a lot of these things still apply when somebody becomes incapacitated. You get hit by the beer truck, but you don't die, and you're in the hospital, and you can't, or you have a stroke or dementia or Parkinson's or Alzheimer's, whatever it may be. These are some of the same issues still apply here. And another thing to think about in a business is, what role did this business partner have? If you have channel partners, and a channel partner is somebody that a business or an entity that a business might have a lot of dealings with, right? And those two businesses are kind of reliant on each other for profitability. That would be a channel partner. Suppliers and really banks, if the person who has all the personal guarantees dies, that's going to be a problem for the bank, right? Because they're going to want someone else to step in with that personal guarantee. Or the surviving partner, it may not be enough to have that personal guarantee. And then what about employees? Will the key employees leave? That often happens. The boss passes away and the employees say, look, this person was the life of this business. I just don't think it can continue on. So I'm gonna leave and go someplace else. And that's kind of like doubly damaging. Right? And will they take business with them? That's a whole other question, right? If they have the ability to take customers with them to a competitor, you really have to pay attention to that. And really, should the business stay in business or not? Sometimes when the person who is the driver of the business, right, and that may be a business partner, one of two or more partners, if that person's the real driver and that person's deceased, there just may not be enough energy to keep it going. So really, you've got some 5 big options when a business partner dies. You liquidate the business, the assets, and close the business and distribute the remaining assets. So if you've got some type of ongoing business and a partner passes away and it just can't be sold, and unfortunately, many businesses, there just is not a ready market for them. Sometimes you just have to close your doors and sell your assets. Oftentimes, if you're going to sell, you're selling to a third party. It may be very uncomfortable to sell to a competitor, especially after the loss of the person who viewed that potential buyer as a creditor or as a competitor. But that competitor might be the person who's best suited to acquire the business and grow their own business. You can become partners with your deceased partner's heirs. And I would say if somebody was a passive investor, like a passive partner, not really engaged in the business, but maybe a finance partner, that may not be such a bad idea. But if it's a law partnership, unless that spouse is a lawyer, that spouse can't be a member of that law firm. So there has to be some type of ending. So that's when you get into the professions. Whoever inherits those assets has to be licensed. There is a middle period. If you pass away, can you pay the estate on earned legal fees? We'll cover that in a little bit, but that is the case. But if you're licensed, unless that person coming in is licensed, they can't even be a member of that partnership. Do you sell the business to this deceased partner's heirs? That's a whole other issue. And we're going to cover this in a couple of slides, but it may be if your partner dies, you say, look, I don't want to continue on with the business. It's just not fun without my late business partner. Let's sell to his kids or her kids or whatever the case may be, right? You sell to their family members. Or again, you buy out your deceased partner's interest in the business. We see that happen quite a bit as well. It really depends on the age of the partners, quite frankly. So we do have a question here. And for those of you who have questions, go ahead and put them in the Q&A and we will endeavor to answer those. Dennis asks, if you're a cosigner on bank lockboxes and the other cosigner dies without a will, are you now the legal owner of the contents? How about cosigners or checking accounts after the other one's death? So that's the difference between a co-owner and a cosigner. So you can have on a bank account, you can have signature authority, which fundamentally is the person who owns the account is delegating their authority to sign on behalf of the account to you. If you're not a co-owner of the account, but you're a signatory on the account, when that principal dies, that power to sign checks typically dies with you. In the case of a safe deposit box, that's a very interesting question. You need to see what your bank's policy is on that, because many banks will not permit a trust to be on a safe deposit box. They only want individuals. And a bank may say if there are 2 names on there, the 2 people have to show up. It depends on if they treat it as an and or an or, but I would ask the bank directly on that and find out what their policy is on that lockbox. So collecting important information. So this is what your business partner dies. You're like, oh my gosh, you have this shock. You don't know what to do. And locate all the insurance policies. So it's very, very important, and have access to the account numbers and passwords. And it's very helpful if you're one of the business partners and you're the only one with access to those usernames and passwords, then you would want to make sure and make a list or keep some record or some mechanism, whether it's the password to your computer, so that if you're going to reset or access to your email, if you're resetting passwords, then you have access to that deceased partner's email. And lists also help you create, create a checklist of all the important stuff you need to do. So in aviation, we have a pre-flight checklist. The reason we have a pre-flight checklist is people who fly with the checklist have less fatalities than people who don't. Okay, so it's just a basic survival. So in that vein, really important to get control of the money. What I mean by getting control of the money is not just getting your name on the accounts, but you really need to now, you're the one in charge. Maybe your business partner was in charge of finances more than you were, but you really need to pay attention to cash flow expenses and most importantly, payroll. We're in California. If you don't pay people on time the way you're supposed to, you pay a really big, hefty penalty to the state. So that's a lot. The last thing you want to mess with in California is people's pay. I would say if you're going through this grieving process and you're a business partner, really rely on your team. I would say to, again, every situation is different, but if your urge is to immediately micromanage, it's time to rely on your people in this time of need. I mean, they are human beings. You hired them. Ideally, they're capable of doing their job. It's okay to rely on them because you're going through things that you're going through. They're also likely grieving too, so that your key people are going to have a deep sense of loss, and they're going to be scared about their jobs. Right? We're talking about what about channel partners, vendors? Who's going to be the owner? There's a lot of uncertainty, and you might find that's the time when people leave. So what we see in the real world is employees typically rally and they keep their customers well served. They really most people do step up to the plate. I would say if you're the surviving partner, be visible. What do I mean by that? Don't hide, because your customer may wonder whether the business is going to stay in business. Call the key customers. If you've got some key relationships, keep them in the loop, talk to them. And I think being more visible ultimately results in less rumors. So this is called, walking the floor or walking the factory floor. It's very important to be there and be present. Also create a succession plan or a new succession plan, right? If you had one, but if you didn't have one, now you realize how important this is to have a succession plan if something should happen to you. And then also, if you're the co-owner going through this, give yourself some grace. It's a difficult time. And grieving is a process. It's not an event. Like set a watch and calendar it. So here's an example. Let me kind of bring this home with an example. Sam and Dan are business partners in FunCorp. Okay. They distribute party supplies nationwide. Dan, who is the decedent, dies, and Sam, who is the surviving partner, survives. Sam and Dan are 50-50 partners, and the business is valued at $20 million. I'm going to show you something that I see happen too often. Sam and Dan never create a buy-sell agreement. They never have a plan nailed down in place that says, look, if one of us separates from the company, whether it's we become incapacitated, we retire, or we pass away, if one of us separates from the company, what is the mechanism to continue the business? That's the whole point of a buy-sell agreement. One person's buying, one person's selling. And Dan dies without anything in place, no buy-sell, no will, no trust, right? And now we have to go through a probate, and Dan's only heir is Dan's 5-year-old son, Danny Jr. Dan's ex-wife, right? How do you think Sam's going to feel about this? Dan's ex-wife is appointed executor of Dan's estate because she's standing in the shoes of Danny Jr., right? A guardian ad litem, which means a guardian by the bedside. It's Latin, meaning somebody is appointed by the court to look after Danny Jr., who is not Danny's mom. And so now you've got another set of stakeholders in there, right? You've got the guardian ad litem and the guardian ad litem's attorney. So I will tell you, the probate court will get up all in the business of FunCorp, and they'll be questioning business decisions and reviewing things. And if Dan's ex-wife does not like Sam, which oftentimes is the case, that's going to be a real problem for Sam. So what are Sam's options? What can he do? Well, Dan's death taxes are due 9 months after death. And the court orders Sam to make a distribution from the corporation to pay the taxes. This is something a superior court in California, a probate court, has the power to do. This forces Sam to sell the business to a competitor. Something else to remember, Dan gets an adjusted cost basis. When you pass away, if I buy something for $1 and it's worth $10 and I sell that thing for $10, I'm not paying I'm not paying capital gains taxes on that. So Dan's side of the family, you know, Danny Jr. and Danny's mom, they're all saying, yeah, go ahead and sell the business because they're going to pay less taxes than Sam will because Sam's still alive. Sam didn't pass away. So Sam didn't get an adjusted cost basis, meaning whatever he put into the business and then what he sells it for, that gain, right, that return is going to be paid in taxes. And so the $20 million company is sold to a competitor for literally pennies on the dollar. Maybe it's sold for $10 million. Sam nets half of 10 minus his taxes. He nets about $3 million. Now, remember, Sam had been making $1 million a year in my hypothetical. Each partner was making $1 million a year on a $20 million business. If I went through this kind of fast and you don't understand it, that's okay. Just understand, if you don't have a plan, you don't have an estate plan, you don't have a buy sell, the probate court is going to be in there, really having a heavy influence on the running of the business. And I don't think anyone watching this even if you're a probate judge, right, watching this, you'd be like, well, I wouldn't want that to happen. That was my business. So what do? What if this should say, what if there is a plan? Instead of Dan owning a $20 million business and now earning $2 million a year, right? Well, this is if there's no plan. If Dan owns a $20 million business, right? Sam and Dan, they lose that income, they lose the business. If you have a business, you really want to consider a buy-sell agreement. So what is a buy-sell agreement? So this is if there is a plan. If there's a buy-sell agreement, what is that? It's just an agreement that says if one partner separates from the business, there's a mechanism to cash that partner out. That's all that we're talking about here. There's typically established a method for valuation. You know, how do you value a business? And it's an agreement. You can value it any way you want. Sometimes people say it'll go to an appraiser. Other times people say we'll take some multiple of the prior 3 years' earnings. And sometimes we say we just agree that it's this value. Okay, we agree that it's $20 million, whatever the number is between the two of them. There are two kind of big flavors. There's cross purchase and redemption. These are big words. Don't get like worried about them. Cross purchase, all that means is that the other owners, in this case, Sam, buys out Dan's half. That's all that means. So cross purchase means that one of the other owners buys the shares from the deceased owner's estate. And then a redemption is where the corporation itself buys the shares back from Dan's estate and then gives money to Dan's family. So slight nuance there. In this case, Sam ends up with everything anyway, so it's not a difference. But if you have multiple partners, I think you can see it's a slightly different structure. This is often funded with life insurance. So what do I mean by that? Let's say Sam and Dan agree that the business is worth $20 million, right? They're still partners in Fund Corp. Before Dan's death, Sam and Dan create a buy-sell agreement. The agreement says that on Dan's death, Sam is the beneficiary of Dan's $10 million life insurance policy. Okay, so Sam is taking out a policy of life insurance on Dan, so that when Dan, who's dead, right, Dan dies, Sam, the survivor, gets the death proceeds, and then Sam buys the shares from Dan's living trust, because Dan was divorced. He had Danny Jr. Maybe he named his brother Bob to serve as trustee of Dan's estate. So the guy who died names a brother to be the successor trustee, and that trust then captures all the money. The ex-wife's cut out, the guardian ad litem's cut out, the probate court is cut out. So here's the big takeaway. If you're a business owner, consider getting a buy-sell agreement, and please make sure you have a properly created estate plan, because it makes everyone's life very difficult. So we do have a blog post on this on our website, how to plan for business succession and the sale of a business. And we also have a QR code here that's new for today. So you can just scan this. If you're watching it, you can hit that with your smartphone, and that takes you to the blog post, and you can read more about that. This is part of getting an A team, right? And here's me. I'm like the fifth guy in here, I guess, with my book, Savvy Estate Planning, which you can buy off our website. And get your A team together, because you're going to need your CPA, your financial advisor, and your attorney involved with a buy-sell agreement. It's something where you bring everyone in, all the 18 players. Death of a spouse. Okay, this is really important. And something a new rule was released last Friday. So this is kind of hot off the IRS presses. The first thing you need to do when a spouse passes away, after you go through that initial, disposition of remains and that sort of thing, I would say within the first 30 days, you absolutely want to reach out to your lawyer. That's really the first call to make. When a spouse dies, there are more legal and financial considerations than when somebody does not leave a spouse. Let me put it that way. So a lot of people say, well, this is really easy. I'm on title, or I'm on the living trust. I'm inheriting everything. I'm the successor trustee. I don't need to visit with anyone. That's absolutely wrong. Okay. Number one, right out of the gate, is you get an adjusted cost basis on your assets. If you're in California, if it's community property, by and large, you're getting an adjusted cost basis on your assets, meaning if you bought that rental property for $100,000 and it's now worth $1 million, and you're the surviving spouse, typically you can sell that property for $1 million and not pay capital gains tax. That has to be documented. Okay. And think about it. When you file your tax return going forward, you get an adjusted cost basis. That means you can redepreciate your property. So if you don't understand what depreciation is, it's where the government says, if you have rental property, we're going to pretend that in 27.5 years, this whole, single family home that you're renting out is going to fall down. The structure will fall down. So we're going to give you a 1 divided by 27.5 income tax deduction every year. That's prorated monthly if you buy the house or sell the house during the middle of the year. So it's important to understand that if you don't get your assets reappraised, right? Meaning if you don't get your assets, you figure out a new value, you're going to be missing out on some real income tax savings. And remember, if you're filing single, you're filing at a higher rate. So your tax rate's higher than married filing jointly. So, and by the way, if you're looking for well, Jim, what are the 10 things I have to do, if my spouse passes away? They're different for everyone. Okay. And so it really depends on the type of assets that you have and the size of those assets. Now, portability. What is that? We're going to talk about portability in the next couple of slides, but portability basically says that you get to inherit your spouse's death tax exemption. Right now, it's a little over $12 million. If you're married, it's $24 million. It used to be that when one spouse dies, you would lose that $12 million. And as the survivor, you would only have the remaining $12 million. Portability says you can inherit that. So one spouse dies, the other spouse inherits that $12 million exemption. So my wife dies, I file for portability, which is the Form 709. I now don't have $12 million I can leave to my kids. I can have $24 million that I leave to my kids tax-free. Anything above that's taxed at 40%. You may say to yourself, well, I don't have $24 million. I only have $12 million. Why should I care? It's really important because in 2026, that $12 million number is going to be cut in half to $6 million. And by the way, the government can change that at any time. The government can say, yeah, well, back in 2022, you could leave $12 million per person. But you know what? The government's not getting enough revenue. We're going to drop that tax-free coupon, that amount you can leave tax-free, from 12 million to 5 million or $1 million or whatever it is. But that portability never goes away. So if you lose a spouse in 2022 and that spouse has unused death tax exemption, which in most cases, that's what happens when a spouse dies, it's pretty much all unused, that 12 million can then pass to you. And even if they drop the exemption to $1 million, you have $1 million plus the 12. So you have 13 million. So I would say, if you're a lawyer watching this, it is probably malpractice not to advise a surviving spouse to seek portability. Contact Social Security. You may be entitled to survivor benefits. It's very important. And the number for Social Security is 800-772-1213, or visit your local Social Security office and find your spouse's estate plan. This is really important. Your living trust, your spouse's estate plan. If you guys have separate plans, bring both of them into the lawyer's office, and I'll tell you why both of them come in. Or if it's a joint plan, which is the case generally in California, you would want to bring that estate plan into the lawyer's office. The reason is, if you have a lawyer, you might have done an estate plan with that lawyer. That lawyer might be retired. That lawyer might not know that you went out and you made a change with another lawyer, right? Because maybe that lawyer was on vacation and you were going on vacation and you needed a quick amendment. So bringing all those documents to your lawyer, that's very important, because these documents really drive a lot of the decision making. So portability, I did explain this. Here's a little more color on this. You have the $12 million coupon. You can gift $12 million. $60,000 free of death tax, free of gift tax. When you die, this means you can leave $12,060,000 without any death tax, any federal death tax or a state death tax as well. Portability is where you combine your gift tax exemption with the unused exemption of a deceased spouse. So then the survivor doubles up. So something not to ignore if you lose a spouse. So question is, to get the step up in basis on the primary residence based on the time of the spouse's death, the spouse has to have been on title, correct? This is interesting. I would say not necessarily, because when you said the spouse, let me break this down. If it's a community property asset, you get a full adjusted cost basis. If I go out and I have earnings and I put $100 in earnings into an account that just has my name on it, I'm married, that is community property. It just has my name on it, but that cash is community property. My wife has a 50% interest in it. Likewise, if I take that $100 and I buy a house, I'd maybe add a few zeros and it's just in my name, it still may be community property, even though it's in my name. Now, there is a wrinkle on this in California. There's this rule that says title controls. If I'm the spouse who's dying and it's my separate property and I leave it to my spouse gets a full adjusted cost basis and she can sell the property and not pay tax and pocket the money. If I am on title to the property solely in my name and it's my wife who passes away, that's a little bit tougher example, because arguably I don't get any adjusted cost basis if in fact that was my separate property. So I might have to go through a prove up process to demonstrate that it is community property. So living trust, find your spouse's estate plan, including the will and the living trust. Again, your attorney should have at least a copy of it. Some attorneys keep originals. That's kind of an old school way of doing things, which, if we kept all of the estate plans we did, it would kind of look like that scene at the end of Raiders of the Lost Ark with that big cavernous thing with lots of boxes in it. That kind of scares me to keep that many original documents. And something to remember, the surviving spouse is often designated as the sole remaining beneficiary. So if you're worried, like, oh, what happens, do I have to give my kids money, or do I have to give my late spouse's children who aren't mine, my stepkids, do I have to give them money? Well, it depends on what your estate plan says, right? But I would say generally, broadly speaking, most estate plans that we see, the surviving spouse, the spouse who didn't die, the surviving spouse is the successor trustee, is the person who handles things, and typically is, broadly speaking, the beneficiary of that trust. And it's really not until the second death, in most cases, where the kids or other people inherit. So let's move on to death of a spouse. What if your employer dies? Now, this is kind of a weird one. So what happens? This is just really kind of crazy. Who thinks about their employer dying? Well, it happens. And I mentioned at the beginning, all of these things have happened in my practice. So you're going to want to notify the, actually, this should say employee. Hold on. Oh, this is okay. So this is your, anyway, I think this is supposed to say employee. Notify your spouse's employer. So if your spouse is employed, notify their employer. Okay. The Human Resources Department can help with a lot of information. There are retirement and pension plan benefits. You do need to check in. And many times, this is super important, stock options are accelerated at death in many instances. So stock options typically have a vesting period. So if I start in a company, they say, oh, well, in 5 years, you'll get this, amount of stock. In 7 years, you get this. And in 10 years, you get that. Well, many times when a person passes away, all those are accelerated currently, and there's typically an expiration date on vested options. So this is something not to just assume that what the documents say is what's going to happen in the future, but death, the fact of death, can change the terms of the employment and change the terms of the stock options. Ask about continuing health insurance coverage. When your spouse passes away, your spouse is not an employee because they're deceased. And that leaves an open question. What about your own health insurance? So definitely reach out to the employer and notify your employer as well. Now, a lot of people don't think about this. A lot of people think, hey, if my spouse dies, why should I notify my employer? This may be a life event that could trigger some benefit decisions for you. So certainly if you have a pension, if you've got health insurance, other things, you're going to want to check in with your own employee. And check in with your spouse's former employers. You might be the beneficiary of a life insurance policy, some type of pension. A lot of times there are these old leftover 401ks that people just kind of forget about. There might be, a lot of money. There might be a little bit of money, but a lot of times people forget. And then also ask the funeral director for certified copies of the death certificate. Common question is, how many death certificates should I need? Typically, it's one per parcel of real estate. You do get those back once the documents are recorded. And then many times one per life insurance policy or one per IRA. So, that can be, it's not uncommon for people to get 20 death certificates. So Anonymous asks, I can't get my brother to do a living trust with his wife. He keeps saying that it all goes to each other on the first death. They will do it after the surviving spouse gives it to the kids. On the first death in a marriage, is it terrible not to have an estate plan if everything is in joint accounts? Well, Anonymous, couple of answers on that. Number one, it depends on if property is community or separate. And in California, the spouse inherits all the community property and a portion of the separate property, depending on how many children you have or how many children you don't have. So it just, whether you have children, one or more than one, the surviving spouse inherits a different amount of separate property. The other danger with jointly held property is it depends on the health of the surviving spouse. So people can die together, pretty improbable. It's not so improbable that a couple might be in a car accident together, one dies and one is completely, injured where they can't perform any functions, they can't do anything. Where I'm going with this is that spouse may not be able to do an estate plan, or that spouse may have a cognitive impairment like stroke, dementia, Parkinson's, Alzheimer's. There may be something going on there. So Anonymous asks, for California community property real estate assets with low basis and one deceased spouse, is it reasonable to establish step-up basis by using a real estate agent broker experienced in the local market who provides comps and an opinion of value letter versus a full appraisal that might be more appropriate after the death of the second currently elderly spouse? Anonymous, you must be a real estate professional. The way you wrote that was a very good question, very well written. Here's my thinking on that. I think it depends. I think if you have, if you have a multifamily and it's a 50 unit multifamily, I'm probably going to get an appraisal because I want a very specific allocation. It's not so much the value per se, but the allocation of the value of the structure versus the dirt, because we're talking about depreciation, an income tax issue. If it's a personal use asset like a house, I'm less concerned about that. I will tell you officially as a lawyer, I would say always get don't go off a broker's opinion of value, go get a real appraisal. That's what I'm going to tell you as a lawyer, but can you save $500 here and there? Yeah. But I think that's kind of a legacy of almost like a poor person mentality. Like, oh my gosh, I can't afford to spend 500 because if I spend 500, I won't be able to eat in 3 weeks. Like that is not the case. Okay. I suppose sometimes it could be the case, but in the vast majority of cases, if the question is, gee, I'm going to sell this property down the road and there's a significant capital gain, I know personally, I would feel better if I had a real appraisal. Okay. Because if that's audited, I can tell you, I have experience with IRS audits with clients is, you're going to want that well documented is the bottom line versus a single piece of paper that says, yeah, it's worth 500,000. All right. So we're going to move on to, if your spouse is a veteran, check with the VA, Veterans Administration. You may be eligible for VA benefits as a surviving spouse of a veteran. So it's very important to pay attention to that, especially when it comes to long-term care and aid in attendance. That's a very common benefit. Notify all insurance companies. You can ask for the links to websites or hard copies of the forms. And the sooner you start, the sooner you'll receive your benefits. This would be like life insurance and any sort of death benefit related to that. And then change the property titles. And I would say through your lawyer. Think about removing your spouse's name. One of the things that happens is when a spouse is on title to real property, a redacted version of the death certificate is recorded. It's a public document. The social security number is blacked out, so you can't see the social security number, but there's a lot of personal information that's on there. Mother's maiden name, father's, name of the father, date of birth of the parents of the person who passed away. So there's a lot of personal information on there that I think is frankly probably too public, for lack of a better term. And you want to make sure and remove your deceased spouse's name from credit cards, from all these things, so that people can't get a hold of this publicly available information and wreak havoc with your credit. So changing titles on the joint bank account, investment, credit accounts. I would say that the credit accounts are kind of important, right? You want to make sure and let them know, because they can put a freeze on, with the major reporting agencies. They can let the world know that this person is not entitled to credit. So if somebody tries and gets credit on a deceased person, they're not going to get it. And that does happen. Okay, this is where somebody dies and somebody else gets information, and then they apply for credit in that deceased person's name and get money. So you want to avoid that. Meet with your accountant and your tax preparer. I kind of put this last. This is probably realistically one of the first calls you'll be making. The lawyer, the CPA, the financial advisor, the people who are really closest to this process. Another thing is, if you have a child in college, contact the financial aid office, and there may be more assistance that your child can get if you have a college age child. And then update your financial plan based on the benefits you've received. And a lot of times people say, well, when my spouse passes away, my financial picture doesn't change that much. Well, it does, because now you're a single filer. You're not a joint filer. And certainly your tax bill likely will go up pretty significantly. That's just one issue. Secondly, your expenses really won't go down a whole lot, but your income may come down significantly. So this is a reason why you need to meet with your A team. It's that picture I had where I added myself with the book. Get together with your A team, because you need to figure out going forward, what is my budget going to be? What are my taxes going to be? How do all these pieces fit together, and how do you minimize your overall tax liability? And also discuss the long-term retirement and investment options. So they may change, right? When a spouse passes away, that's a pretty big life event, and you do need to get together with your team. The other thing too is, I've heard some people say, and this is primarily from widows, they say, well, I was told not to do anything for a year. I think that's probably not a bad idea on a very high level, which is, don't get married for a year. And probably applies more to men than it does women, frankly. But go see your lawyer, go to your CPA, go to your financial advisor pretty quick. Don't wait a year for those discussions. We do have a blog post, and here's a QR code. If you're watching this with a smartphone, you can kind of click it. And this is estate planning for a surviving spouse. So this is what happens after the deceased spouse passes away, and all the things that a surviving spouse should be doing. So Christian asks, if two members of an LLC are siblings of the manager of the LLC, who is the descendant, would you consider a buy-sell agreement between the siblings? It depends on, Christian, great question. It depends if it's an operating company versus more of a passive investment like real estate. I would say yes, consider it, whether it's appropriate or not, and to what extent. To what extent does this thing, what kind of detail needs to be in there? I would take a look at that, because if it is rental property, for example, you may be fine still, if it's a 50-50 or a third, you might be okay with some of the heirs being along for the ride on that, right? I mean, not a lot changes, but if it's an active ongoing business and the three partners were heavily involved in the business, and these other people are just going to be along for the ride, I think you can see that that's a different situation. Mary asks, does the second home get a step up in basis for this beneficiary? Everything, when one spouse passes away, all community property gets a step up in basis. Steve Jobs he was one of the creators of Pixar. He got a bunch of Disney stock. When he passed away, his wife, I think she inherited about $450 million in stock with a very low cost basis. She was able to, or could have sold that $450 million in stock without capital gains. So that's a big loophole, quite frankly. If you get a step up in basis when a spouse dies, does the property get reassessed? In California, transfers between spouses are not considered changes in ownership. So the answer is no. If you do get reassessed when a spouse passes away, you would want to call us, because that's probably an error on the part of the assessor. Dennis asks, Is the stepped up in basis for primary residence the same for federal in California? Yes, that's correct. So there is something to understand. And this was kind of I remember from law school, my property professor, you take a course called property, and he said, there is no federal property law. And I was like, are you kidding me? Yeah, there are no federal elections. Right? That's in the news. Elections are run, they're county elections. They're run by each county, right? So there is no federal property law. The Internal Revenue Code looks to the applicable state law. What that means is if you live in California and you hold assets as community property, you're going to get an adjusted cost basis. If you move to a state that is a separate property state, let's say you move to New York and one of you passes away, different tax treatment, okay? Different set of rules, different tax treatment. Death of an adult child. This actually happens quite a bit in our firm. And if this has happened to you, it's just, it's terrible. Two of my brothers-in-law have passed away. My father-in-law is still alive. And, it's just, the whole thing's weird when people die out of order. Typically you think the parents would pass away first and then the kids, but sometimes the kids pass away. So what do you do? Well, I think it really depends. If the child is married, has adult children, you kind of may be like out of the picture, quite frankly. This is your child, right? Especially if that child has an estate plan. So if your child went out and did an estate plan with their spouse, and something happens to your adult child, your adult child's estate will likely be handled by the surviving spouse, right? And under normal circumstances, if you can say normal. But what should you do? Okay. And locate the will or trust. This is your will and trust. And this is maybe the adult child's will and trust, because you may have a role in there. Okay. You may be appointed a guardian. If your adult child's not married and has minor children, then that adult child may have appointed you as guardian. That guardianship appointment is in the will, not the living trust. So a guardianship appointment is where your child asks or manifests an intent to nominate you as the guardian of your grandchild. You have to go through a court process because you're going to have a background check. You're going to be vetted. You're going to be investigated. It's all for the good of the minor child, but it's not that your son or daughter appoints you as guardian and that's it. You have to go through that judicial process. That's different than a living trust. Your adult child can appoint you as successor trustee to look after the money for a grandchild. And that does not require court involvement, does not require court appointment. What I mean by guardian is when you sign these permission slips for a kid and it says signature of parent or guardian, the guardian really stands in the shoes of the parent. And planning the funeral or memorial service, again, this is if a child passes away and you're kind of the decision maker, you've got to do that. There's also something called pre-need planning. People don't do this for their kids typically, but they do it for themselves. That's where you go to the funeral home and you pick out your casket and you pick out the kind of cake you want to have served and play whatever music you want to play at your funeral, and you write a check, and that money goes to an insurance company so that when you pass away, all those services are picked. They're essentially a preset pricing, and that death benefit from the insurance company covers that. Review your own estate plan, because your estate plan, if a well-written estate plan, will anticipate the death of a child. So a well-written estate plan will say, I leave everything to my son, and if he fails to survive me, then the money goes this way. My estate goes wherever it goes. You can see where I'm saying, so there's the, if this child doesn't survive me, well, that if has happened. So you need to crack open your estate plan. It's probably written in legalese. You probably don't have an advanced degree in legalese like lawyers do. So you're probably not, you're going to look at it and go, this is too emotional. I can't even figure this out. That's where you would want to reach out to a lawyer and review your estate plan with that lawyer and hand the estate plan to the lawyer and says, look, my son or daughter's passed away. Who gets their share? Tell me, lawyer, who gets their share? What do the documents say? So very important. Any assets that are held jointly with your adult child, pay attention to those, especially real property, because you may be subject to reassessment or partial reassessment on the death of a child. So very important to pay attention to that. And if assets are in your child's name, you may end up in probate court, meaning if your adult child has no estate plan and passes away, maybe they don't have any kids, maybe they don't have a spouse, you're going to be the one doing the legwork. And so that's why it might make sense for your adult child to get an estate plan, right? At least a will or perhaps a living trust. Typically, if you own property, you're going to be looking at a living trust. If you own real property. So Sam dies suddenly, owns a home and bank accounts. Dave, Sam's father, petitions the probate court to be appointed Sam's administrator. The term executor means there is a will and the person named in as executor serves. Administrator means there's no will. It's a term of art. It's like saying sailor for the Navy, and executor might be soldier in the Army. Same role, just a different name. Probate now in the era of COVID is about a 2-year process. And it just continues the grieving process. Sally, on the other hand, Martha's daughter, passes away, leaving 2 minor children and a difficult ex-husband. Fortunately, Martha created a revocable living trust, centered estate plan that helps Martha. Well, this should be Sally created a revocable living trust estate plan that helps Martha avoid probate and keeps the ex out of the inheritance. So the idea here is the daughter creates an estate plan, sets everything up in a living trust, so that the daughter names the mom to look after the grandchild. She'll have to go through court on that, to look after the grandchild's financial interest and also the living trust. Now, something to know is if there is a parent, there is typically no need for a guardianship. That is typically true for guardianship of the person. If a child, a minor child, has more than $5,000, California law typically requires that you set up a guardianship of the estate. And that's not something that automatically happens. It's not automatic that the parent is a guardian of the estate. This actually happened. Someone else's minor child. This is just kind of a, this happened to my son when he was in high school. One of his friends, the mom had died, and then the dad died when his friend was in 10th grade. Very, very tragic situation. And, you know, what do? You show up. You volunteer to run errands. Take the other children to the park to take them out for ice cream, send cards and emails, tell them you're glad to see them. And it's okay to say, you look, if you want to talk, that's fine. If you don't, that's fine too. And I had this happen. A girl I dated in high school passed away, and in her 20s, and I still think about her. And it's something I talk to her parents about. So sharing your memories is okay. And then talk to your own children, you know, because they're going to be going through their own grieving process, but talk to them about that as well. So this is a little less legal, and it's more just, you know, more human. So death of a tenant. This is like, this happened to my parents. They have a property, and one of their tenants passed away. So all of these things have sort of happened in real life here. This is really important. Death does not terminate the lease. The tenant's estate is obligated to pay the rent through the end of the term of the lease. Now, if it's month to month, it's 30 days after the last rental payment, right? So if you have if a tenant is on month to month, you know, you're going to clean the place up and relet it. There's no 30-day notice required. The estate remains liable. The estate of the tenant remains liable for unpaid damages. And that's also subject to your landlord's duty to mitigate damages. So if you're sitting on a 2-year lease and the tenant dies a year into the lease, if you sit on your hands for 23 months, that's not really a good idea. You need to make your best efforts to get the place cleaned up and re-rented. You have to duty to mitigate your damages. And the tenants, important to understand, the tenant's family members and children and heirs are not personally liable for the rent. It's the tenant's estate. Any security deposit can be used to pay amounts due. What if you find a body in there? First of all, don't touch it. This has happened many times in probates that we've handled over the years, where somebody discovers a body. These can be pretty gruesome situations. Call 911. If it's a homicide, a suicide, accidents, or sudden natural death, the coroner typically takes custody of the body and does notify the next of kin. So that's when the coroner is involved. If you're on hospice, typically the coroner is not involved. So hospice is a switch from curative care to palliative care, and oftentimes that's done in the home, and that you do not have the coroner notification. And if the death occurs off the premises, you know, if you learn that your tenant's passed away on vacation or out for a drive or something, you should get the contact information for the responsible party. Any pets, you know, if a pet's in the unit, then basically you notify animal control. So if someone's got a dog and the tenant dies and the dog's there, you're going to call animal control. That's called an involuntary deposit. So what happens if there's no next of kin? So you have a tenant living there. You don't know where the person's family members are. The tenant dies. The local county public administrator, and this is a California thing, 58 counties, every county has a form of public administrator. Either it's a full-time employee or contract lawyer typically. And they will typically secure the premises and then look for next of kin. They may start a probate action. And then the question about the tenant's belongings, they either will take those belongings to a secured location for disposition or auction, or if it's of low value, if it's food in a refrigerator and clothing and things like that, then as a landlord, you've got to follow the rules for abandoned property. And those are kind of laid out by statute. And I would just say, don't just because you have a key and can enter the property doesn't mean that you should. Really get the permission and to best practices is presence of the next of kin or a police officer to walk you through the place to do a sweep, if you will, and avoid self-help. So this is where you want to hire a crew of people to do stuff, right? If you're the landlord and you go in, they'll say, well, where were those gold bars, or where was that big pile of cash? And you're like, there were no gold bars. Come on, people. It's good to hire a third-party company to do that. And the landlord does have to contact the executor or trustee or administrator if litigation is necessary to recover rents or possession of the property. The other thing too is you have a 3-year disclosure requirement if somebody dies in the unit. So for 3 years, you have to disclose that somebody passed away in this unit. So what about death of a boss? What if your boss dies? What do you do? The short answer is, most people work in really small companies. And if your boss dies, you probably should start looking for another job, frankly, because you're supposed to get paid. If you've done the work, you have the legal right to be paid for it. If the business is incorporated, if it's not a sole proprietorship, in theory, it should survive the death of the individual, even the owner. Can you sue for your pay and seek recovery from corporate assets? Yes, but in the real world, ITRW, in the real world, businesses are often running, they're barely making ends meet. And I got to tell you, we're going through a time right now where a lot of businesses are really getting hit hard by inflation. You have wages going up, cost of goods going up, customers not wanting to pay the higher prices, and that money's got to come from somewhere. So, a lot of times it's a kind of a one-man or a one-woman show. And yes, you are entitled to get paid, but sort of good luck getting paid. And we have an example. I pulled up Bob Ross's tomb here. Bob died unexpectedly. IRP is owed 2 weeks of pay and accrued PTO. Bob's estate's liable for unpaid wages. Now, in this case, Bob Ross has a fairly decent estate, right? But if Bob died without a living trust, IRP has to file a creditor's claim in probate and wait for months and months and months to get paid. That's a tough one. I just don't think people are going to get paid on that one. So if it's your situation where, you're working and your boss dies and there's no trust and there's no corporation and there's nothing there, your chances of getting paid, I think, are pretty slim. Death of an employee. So what if your employee passes away? You must comply with the state and local laws on final payments to the estate of the representative. That means the last paycheck, accrued PTO, everything. It's as if they separated from the company. You have to pay that person. Is it okay to write a check to a deceased person's name? Yes, that's an asset of the estate. Okay. And then, the heirs deal with it, but you've got to comply with your local laws. And employers actually may have additional legal and administrative obligations. And those would be under benefits plans, contractual obligations. There might be a life insurance premium in there. Certainly 401k is going to have a beneficiary designation. And then if the death occurred at work, obviously there's workers' comp, any injury or death that occurs at the workplace during work is treated differently. And then if the employee died from COVID-19, you do have an additional reporting requirement. Even if you're not named so death of a friend, what happens when friends pass away? I know a lot of people have friends that pass away and they help out. Even if you aren't named as successor trustee in a living trust or executor in the will, there are some things that you can do. Just bear in mind, you're acting on behalf of the estate and the beneficiaries. You can provide useful assistance to them in, in a very difficult situation. You can help contact some of the companies, get that ball rolling, right? Utilities and insurance companies. And many times these companies get it because this is how it works. The family's devastated. They have friends that they lean on to help them out. And so that at least can get the ball started. Sometimes you can complete the transaction and sometimes not. It just depends. So here's some things that you're going to have at the ready. Get the full name of the deceased persons and their address, and zip code is as you know, frequently asked for. Date of birth and the mother's maiden name, maybe first make a car, first pet, whatever these security questions are. Or you can just call the companies and ask them, what's your process? Bob died. How can I help? What needs to be done? As long as they know about the change in circumstances, they typically are helpful, with some exceptions. But the other important thing is by contacting them, they effectively freeze the accounts, and then they can kind of walk you through next steps. So very important, get your A team. There I am with my book. This is the end. Our book is available on our website. Second edition is out. Savvy Estate Planning, What You Need to Know Before You Hire the Right Lawyer. This is the book you read before you even go to the lawyer's office, okay? This is a primer because these are all the questions a lawyer will ask you. Check out our YouTube page. We have lots and lots of content, and we post new YouTube content every week. And subscribe to our YouTube channel. Here's our website. Here's how you contact us. We do offer a free call. You can just call in and you can talk to a human and get that process started. And please review us on Google. If you're a client or you're just, like our webinars, please just Google Cunningham Legal, and then our location will pop up and you can write a review. So we have some questions. Let's see here. We have, if you have a living trust, do you take care of portability now, or is it the time of the first spouse's death? Portability happens at the death of the first spouse. Linda has a question. An administrator can be appointed even when there is a will. There's administrator with will annexed. That's correct. That's when your executor, when your person is not named. There is a will, but no one is there to serve. You run out of people. That's administrator with will annexed. Thank you. And see, some people, as well-intentioned people, may incur expenses. Pre-appointment expenses are generally not recoverable as they're not considered creditor claims. So people shouldn't rush to get help. Get family or the public administrator involved. Thank you, Linda. Thank you for that. It sounds like you're a lawyer. So it's very important to understand that if, there's a saying, no good deed goes unpunished. You want to make sure that you're following the rules. But just remember, once you start helping somebody, you've got some responsibilities that go with that. Mary asks, if a sibling is a beneficiary for a primary and second home, do they get a step up in basis? The decedent gets a step up in basis. And I think, Mary, what you're asking for is if two siblings own a home 50-50, do you get a full step up in basis? No, you get a partial step up in basis. Only married people can own community property. Okay, so if you have two people owning a property who aren't married, at most, you're going to get a 50% adjusted cost basis. How are crypto wallets, keys, and NFTs handled with death? Anonymous, we have a webinar on crypto. The short answer is it depends on the nature of what it is. Typically, the person with the password owns it. Here's the problem with crypto, and it's something you need to understand. A court has no jurisdiction over crypto. Zero. Where is crypto? A court has jurisdiction over people. A court can order a company, a court can order an individual who may have a hard token to turn it over, right, or hard key to turn it over, but they don't have jurisdiction over crypto itself. If my landlord dies, do I have to move out? Anonymous, fantastic question. If your landlord dies, that lease agreement that you signed is still in effect, okay? It's attached to the land. It runs with the land. So what I mean by that, if you're on a month-to-month tenancy and your landlord dies, yes, they can give you a 30-day notice to leave, or 60-day, depending on how long you've been there. If you have a 5-year lease, you're still on for 5 years, right? So the door swings both ways on that. In California, is there a negative estate, meaning more liabilities like loans over assets? Do they still need to go through probate, small value estate, easy process? I have a negative estate question, meaning the assets exceed the value of your estate. That happened a lot in 2008, Anonymous. That's one where you may want to just let all those assets get repossessed. Let the house get foreclosed on. Just don't do anything, okay? That may be something to consider. Remember, the 13th Amendment to the United States Constitution outlawed slavery. It also prohibits involuntary servitude, meaning just because you're named as successor trustee does not mean you have to do it. Just because you're nominated as executor does not mean you have to do it. But if you choose to do it, then you have a whole bunch of responsibilities that go with it. Well, that brings us to the end of today. I want to thank you for joining us today, and we look forward to seeing you on future webinars and on YouTube.